All right. Today, we'll be discussing agency law. I see agency law as a great foundational um, knowledge base that will help us understand the things that we'll be studying in our next class, which will be employment law. Agency is much like employment law. They share a lot of the same language. And um, again, you'll see the relationship here as we move through the discussion of agency. I always like to start this class with this quote. Sorry, don't want to share. I want to present with this quotation from Joseph Story, where he says it's a universal principle in the law of agency that the powers of the agent are to be exercised for the benefit of the principal only, and not of the agent or of third parties. This and I think most people understand this. If you're hired as my agent, I hire you to buy a house for me or enter into a contract for me, for example. Well, because I've hired you to do that, if you find the perfect house for me, but then buy it for yourself, well, you're going to be in breach of our agency relationship, our agency contract. You are hired to do all of that stuff for me and me only. That's why I hired you. Now, at this point, I usually like to have a discussion with the class about agency in the church setting. And I find this discussion quite interesting when we talk about agency. Oftentimes I'll ask a student, like what does agency mean? If we were in Sunday school and I asked you what agency means, and you'd say, well, it means that I have the choice to do what I want. Well, do you see the conflict there? Right now I'm telling you the agency basically means the opposite of that. You don't get to do what you want. You are hired to do what is in the best interest of somebody else. That person will call the principal, as you'll see here in a second. And if you do whatever you want, well, that's a violation of the agency relationship and your duties as an agent. And I think that this sparks a really interesting discussion about agency and what it really means, and how some of us may have misinterpreted the use of that language in our religious discussions. Uh, think of it like this: our agency, if we are agents, well, who are we agents of? Who is the principal? Right? And if we decide that Heavenly Father, for example, is the principal and we're agents, and we've been given agency for Heavenly Father, does it really mean that we can do whatever we want? Or does it place upon us more responsibility? And does that word have deeper meaning? So just something for you to consider. Here, this slide is mostly definitional, and I introduce this idea of fiduciary responsibilities. This is something that will come back to throughout the rest of the semester, what's left, especially when we get to corporate law and corporate corporate duties. But I want to introduce it now. Many of you have heard this before, like, oh, I have a fiduciary, or we have a fiduciary relationship, etc. Really what it means is this right here. It mimics much of what agency is. If you have an agent, oftentimes they'll also be a fiduciary. But let me tell you of just a little nuance that I've come to find. Usually when you're talking about a fiduciary, it means monetary responsibility as well. So if you're my fiduciary, if I ask you to go buy something for me, for example, or I entrust to you my money, my funds, whatever that is. Well, again, fiduciary just kind of implies that you've got responsibility to use that money well and in the best interest of me. So that's how I see those two overlapping. Again, the second paragraph here, the agent agrees to represent or act for the other, called the principal. So if you're acting for me, I'm the principal, you're the agent. And yeah, so this slide is meant to just introduce you to some abbreviations that I use. My employment law professor, Professor Lobel at University of San Diego, she always used these. Her law professor probably did the same thing, and back forever. Anyway, if you see an ER, that just stands for employer, and EE means employee. So this is just for you to kind of catch on and interpret what it is that I'm saying. I think in the exam I never use these, but just so you know, it'll make more sense as we go through. And then of course the last statement on this page deals with employees, and usually an employee of a business will be deemed to be an agent of that business. Now the limitation here is that it's limited to the scope of their employment and what a reasonable person would expect the scope of their employment to be. Hence the James Franco reference in the reading for this chapter. If James Franco is working at McDonald's and offers to sell to you the formula for McDonald's secret sauce, can he do that? Well, a part of you may be like, well, he's an employee of McDonald's, so he's an agent of McDonald's, so therefore he can bind McDonald's and require McDonald's to give me the formula for their secret sauce. Okay, don't lose your minds over this. Like don't just keep your logic. If that doesn't sound right to you, it probably isn't right. And an over-the-counter employee at McDonald's, just simply a reasonable person wouldn't expect them to have that authority to distribute or sell whatever the formula for McDonald's secret sauce or Coke's formula, etc. Like, no, if it's not the CEO, they probably don't have that authority. So just something to keep in mind. And this is where I'll introduce the idea of independent contractors. We'll come back to independent contractors towards the end of the semester when we talk about tax issues, especially as it applies to employees of a business versus independent contractors of a business. But today I'll introduce that, and it'll mostly make sense. Many of you, by the way, have been classified as independent contractors sometime in your life. Summer sales companies are notorious for one, for classifying their workers as independent contractors, and perhaps many of them misclassify their workers as independent contractors rather than employees. So the key here is that an employee is somebody that the employer has more control over. I'm simplifying things. We'll talk more about this next slide, but just know that's one issue. Whereas an independent contractor, it's more like if I hired somebody to fix my or remodel our kitchen, for example, that I'm not going to micromanage everything. I'm just going to tell them, get it done. I'm going to write them a check. Voila, it's done. Are they my employee? No, I'm not. I don't have to withhold taxes for them. I'm not in the business of remodeling kitchens. And so, to call them an employee would be rather silly. So they'll be an independent contractor. I'll just write a check, no taxes withheld, which means they'll be in charge of paying their own taxes. And so anyway, this slide is interesting because you've seen it. There tends to always be construction around BYU, Idaho. Are those construction workers? Are they employees of BYU, Idaho? And some of you are thinking, no, like they have beards and stuff. And that's one dead giveaway that I'm going to tell you that they're independent contractors. But you can kind of work through this. These are people that BYU, Idaho gives a job to, says, hey, please demolish this building, and in its place, put in a parking lot. And then they say, we'll give you money if you do it. And then they walk away, wait for the company to finish. I'm simplifying things here. And as soon as it's done, voila, you pay them the money and they're gone. They're independent contractors. Okay, those are not employees of BYU Idaho. Now, these are the considerations to determine when deciding whether somebody is an employee or an independent contractor. Think of these 7 factors much like you did the factors to determine whether fair use is an appropriate defense to copyright infringement. This isn't like a formula where if you get 4 out of the 7, then you're that. Again, sorry, accounting majors, but this is a sliding scale, and you're going to go through each one and kind of weigh it out against the others, and yeah, and then we're going to make a decision. So again, how much control can the employer exercise over the details of the work? If they're exercising more control, that looks like an employee. If they're exercising less control, independent contractor. All right, is the worker engaged in an occupation distinct from the employer? For example, BYU Idaho, we're in the business of educating minds. The construction workers, well, they're in the business of not doing that and fixing things or repairing things or demolishing or building, whatever the case may be. So if it's distinct, that looks more like an independent contractor. If it's, and sorry if I'm mixing up my hands here, which one is which. If it's the same, then maybe that's an employee. All right. And you can just go through all of these. Does the employer supply the tools? Well, if they supply the tools, that looks like an employee. If they don't, if the workers are supposed to bring their own tools, materials, trucks, etc., well, that looks like an independent contractor. Again, just kind of weigh these things out. And again, at the end of the day, you're going to make a call. Now, when I test you on this on the exam, it's not going to be like come down to a 50-50 thing. It's going to be pretty clear whether or not somebody is an employer or an employee. But I thought it'd be pretty good to just go through a couple examples to help you kind of understand and start doing this analysis. Now, some of these examples are going to be tight ones, close ones. Sometimes where the decision of the lower court gets overturned on appeal and then overturned again. But it helps you see the analysis, which I think is the most important one. So this is a case from, it's probably been like 5 years now, but you had a TV station in Puerto Rico, WIPR, and this was an interesting thing. They had a morning talk show on the TV station, and there were 2 hosts, a male and a female, and the woman, in this case, ended up being fired. And whether or not she could sue for wrongful termination really it required her to be an employee. If she was an independent contractor, then her claim doesn't matter. It gets thrown out because you can fire independent contractors more easily than you could an employee under discrimination laws, is what this came down to. And so here's the deal. Every morning, so she would wake up at like 3 a.m, try to get to the studio around 4 or 5, and then I think the morning show started at 6. Okay, so every day she would do this. She'd get up, drive to the TV station. As she walked into the studios, the manager would have a contract there for her to work for that day, classified her as an independent contractor, said, here's your independent contractor, sign it. She would take it. It would say, we'll pay you $1,000 for working today. And you're an independent contractor. She signs it, gives it back, goes through hair and makeup, reads the script, eventually gets on the set with her co-host, and they do the morning show. All right. She got pregnant, as you can see on this slide. And when she got pregnant, the manager said, like, I'm going to take some liberties here in interpreting what he was thinking, but I imagine he thought something stupid like, crud, Jane's pregnant. She's going to get fat and nobody wants to watch that. And she's probably going to get moody. let's just stop hiring her. And so when she came in to sign her independent contractor contract for that day, uh, they withheld it and said, you're done. Like, don't worry about coming back. All right. Now, if you hire if you fire an employee because she gets pregnant, well, that falls under discrimination laws, and you can get sued for that. If it's an employee, you can't if it's an independent contractor, because it's an independent contractor as opposed to an employee relationship. And that is something that we'll discuss more on in our next class, by the way. And so, but she sues. Okay, she sues, and the theory is I was misclassified as an independent contractor when in fact I'm an employee. Well, pause the video for a second, and I want you to come up with a couple reasons why she probably that she's going to argue that she wasn't an independent contractor. All right, so go ahead and do that right now. You can go back to the slide previous to the one that you're seeing on the screen. Okay, now that you paused it and we're back, let's talk a little bit about this. How much control did WIPR exercise over this woman? Well, a lot. Like, she wasn't writing her own script. Sure, she'd shoot from the hip every once in a while with guests on the show and jokes that she would say, but in large part, much of what she said was on a screen in front of her that she was reading next to the camera. And so they were controlling a lot, not only what she said, but what she wore. Like she wasn't bringing her own outfit every time that she'd go to the studio. They had wardrobe. They also had hair and makeup. So she wasn't bringing in her own hair and makeup people or doing it herself. She'd go sit at hair and makeup at the studio. So again, lots of control over her. Yeah. Does she engage in an occupation distinct from the employer? Well, she's a morning show host. They have a morning show. So that's very similar. Again, look, like all of the things that we're talking about so far look like employee rather than independent contractor. Is the work done under the employer's direction? You bet everything was. Again, looks like an employee. Does the employer supply the tools? Yeah, we talked about that. Clothing and makeup and all of that. Not to mention all the studio equipment. For how long was she employed? It was a long time. She'd been there for a while. What is the method of payment, weekly or at the end of the job? Well, this one looks more like independent contractor because she was just paid by the day, whereas most employees, you pay them bi-weekly, once a month, something like that. And then what degree of skill? She was a higher skill because of her skills with, well, a niche market of being on TV. So that looks like an independent contractor. But when we weighed everything together, the court said, look, she's an employee. Like, yeah, that's cute that you tried to get her to sign a contract and every day admit that she's an independent contractor, but it looks like an employee-employer relationship. It smells like an employer-employee relationship. It acts like all of that. The court said, look, we're not stupid. We know what you're trying to do. You're trying to save on taxes and trying to be able to fire her more easily. And yet, too bad. It's an employee-employee relationship, and you can't do that. And she ended up winning this case for wrongful termination. And it all came down to this. Now, some of you are probably thinking, my goodness, like that summer sales job that I did, or that summer job at logging trees. People still log trees, but they were trying to classify me as an independent contractor, and yet when I go through those 7 factors, I think I was probably an employee. Yeah, this happens a lot. It saves money for the employer if they don't have to withhold taxes, do all of the tracking, not to mention liability issues, that they are incentivized to misclassify you often as an independent contractor. And so this is something to watch out for and to be careful about. Every semester I have students that come up to me and want to ask questions about this same thing. So let me know if you have questions about that. But again, oftentimes independent contractors aren't. And this can lead to problems for the employer. If they are caught misclassifying people as independent contractors when in fact they are employees, well, the IRS could have an issue with that because, again, the IRS requires, and the federal government requires, that you withhold taxes. Um, and anyway, this could result in fines by the IRS. And so it's very careful that when you're hiring and when you are being hired to ask questions about this. Sometimes the employers just do it out of habit. They may be very thankful if you say, look, I'm an employee. Here's here's some solutions to this. And they may just then think that you're super bright and be very happy that they hired you because you got them out of some potential issues with the IRS. All right. So that's, I think, a decent discussion about this case. Sometimes in class, I'll have students kind of break up in half and argue each side because it wasn't a completely open and shut case, much like this one. So with this case, here we've got ACS. This is a company. Think of them as like the general contractor, and they're doing repairs at St. John Catholic School in Maryland. ACS contracts with HP Trucking. So again, ACS is kind of like the general contractor. HP is one of these subs. HP is a dump truck, basically. It brings in stone from the local quarry. I hate that word, quarry. And it's up here because there was an accident. The driver of HP Trucking ended up hitting somebody named Mr. Perry, who died in this accident. And when the spouse, the survivor of Mr. Perry's estate, so it's, in this case, it's Mrs. Perry, goes to sue and bring a lawsuit against HP Trucking, well, it's just one guy in his dump truck. And he doesn't have a ton of money. He's got maybe $100,000, which is really just tied up in his truck. And anyway, the chance of recovery from this one person isn't going to likely be very fruitful for her, and she wanted more money to compensate for the death of her husband. So she sues ACS. Now, ACS's defense, of course, sorry, HP Trucking was a independent contractor, therefore we are not responsible for, in this case, his behavior. All right. So you have to think of it like that. It's an issue of liability. And remember, employers are usually liable for the actions of their employees. Not so, or not always so, I should say, with independent contractors. And so we go through the same factors again. And in this case, the court found that ACS was an employer. So much like the other one, even though ACS said, sorry, it's an independent contractor, here's the contract that says that HP Trucking is an independent contractor. It's not an employee relationship, therefore you can't sue us. We're free from liability. The court said, yeah, but let's look at the factors. HP only did work for ACS, let's say. He was paid every week as opposed to every job. Again, looks like an employer-employee relationship. They gave him the schedule. So ACS said, okay, you're going to, every day, like, here's how many times you're going to go to the quarry and pick up the rock, etc. So at the end of the day, that's what they decided. Again, employer-employee relationship. Now, this is also true with intellectual property. So in this example here, this, I think we've talked a lot about, like if you create something while working for an employer, then usually whatever you create is going to be owned property of your employer. And so with this one, Brother Snow decides there are no decent accounting textbooks available for students. he writes a text in his BYU Idaho office and publishes it, requiring students to pay $200 a book, because only an accounting professor would do something this insidious. You could see why, and this is, and I think this happened at BYU Idaho. It happens at every school, but I think it happened here. And so, again, like, you can see the issues here. If you're using your BYU Idaho laptop, if you're doing it at your office using BYU Idaho's internet, BYU Idaho's got a claim to the copyright of that book. Hence, that's going to be owned by BYU Idaho, as opposed to if you do it on your own time, on your own computer, at your own house, totally separate from your responsibilities at BYU Idaho, then you can say that you've got a claim, although it's tenuous, because if it's an accounting book and you're hired by BYU Idaho to teach accounting, there's a chance that the school is going to say that they still own it. But and if you work for Google or any tech company in Silicon Valley, good luck. They're going to claim ownership of everything. So just so you know. All right. Formation. This one's pretty simple. And the reading covers this. Even agency by estoppel, I gave a good example in the reading about that. The issue here is just, much like contract formation, agency formation can be express, it can be implied. I could take you to all of my court hearings if I still did that kind of thing. And that would be basically creating an implied agency relationship. If I introduce you as my paralegal, if I introduce you to the bank manager as my law firm's manager or something, you can see that I may have created an agency relationship where one might not exist, hence the estoppel. But or maybe we don't even have an agreement, but we just act like it. Then we've got it either by ratification or just an implied agency relationship. So again, fairly simple. Why is this important? Well, if you go to the bank and withdraw money, the bank may say, well, yeah, your paralegal or office manager, whatever I called you, came and took out money from the account. And I may say, what? Like, they're not authorized to take money out of the account. Well, as long as it's reasonable for them to assume that you did have that authority, it means they're not going to be liable for it. Whereas if I told the bank, don't let anybody take money out of the account except for me, there's nobody else authorized, and then they let somebody else take money out of my account, well, then the bank's going to be liable for that. And so that's the liability issue there. All right, now we get into the responsibilities. So with this one, let me drop this down here a little bit. In this case, the agent's duties to the principal. So what you have to do for me, let's say again that you're my agent, I am the principal, you act on my behalf. Well, you have to perform, you have to do what you're supposed to do, what you agreed to do. Due diligence, reasonable diligence is kind of what we call this. Notification, if you get news about something, you have to tell me about it. Now, by the way, when I'm an attorney for businesses, all of this applies to me as well. If I get notice about something regarding my client, well, I have to pass that information on. Notification. All right, loyalty, I have to act for their benefit, not for mine. That's a big one. And that's the one that I think I focus on the exam. So if you see an attorney that finds an opportunity for his or her client and then takes it for themselves, well, that's a breach of loyalty, the duty of loyalty there. Obedience, again, if you're my agent, you have to do what I tell you to do, unless it's illegal or wrong, or like there's defenses, but any reasonable request that I give you, you have to fulfill. And then accounting, again, if you get paid on my behalf, you have to give me that money. Same with me as a lawyer for my clients. If I receive money that is for my clients, obviously I can't keep that. That would be a terrible breach of my duties. On the flip side, the principal has duties to the agent, primarily compensation. Like, people don't do this for free. So if, like, and on this one, you're just going to follow the agency contract, like whatever is for me and my clients. I've got an hourly rate or a fixed rate to do certain things. They have to pay me that. Reimbursement, if I forward costs from my client, I need to get reimbursed. Cooperation, again, yeah, if I tell my client, here's what we need to do in order to fulfill the responsibilities that you gave me, the directives that you gave me, well, the principal is going to have to do those things. And again, finally, safe working conditions. You can't tell, like, if you're working for me, I can't be like, hey, go into that volcano and get out the diamond. Stupid example, but you know what I mean. All right. Okay, so with agent's authority, this we've mostly hit on. If you haven't seen this movie where this picture comes from, I'm sorry. It's one of the all-time greats. I showed it to my kids and forgot there's a bum scene, so be careful with that. Mike Myers, nobody really wants to see that anyway, but you do see a clip of his bum. So VidAngel it or something. But in this movie, he goes and he's working for Harriet, and she's got a meat market. And again, if he, as a manager, let's say that he's given authority to buy meat for the meat market. No. For our purposes, let's say he isn't given that authority, but Harriet calls him a manager to everybody, including the meat suppliers. Well, is it reasonable for the meat supplier to assume that that this guy, I can't remember what his name is in the movie, but Mike Myers has the authority to buy meat? Well, of course, all managers of meat markets have authority to buy meat. So that's going to be an implied authority, even though he may not actually have it. Or apparent authority is what I meant to say, although it could be implied as well. It's going to be apparent authority as to that meat supplier. The meat supplier is going to say, oh, Mike, you're the, I don't know how to talk like a meat supplier. I just imagine they have Boston accents. Like, Mike, you got authority to buy some meat. And Mike says, yeah. And they sell it, and voila, you've got an agreement. Harriet can't then go sue the meat supplier and say, you wrongfully sold meat to Mike. Why? Because he had apparent authority. It was reasonable for the supplier to think that Mike had authority to buy that. So anyway, ratification, you understand that. You may not have authority as an agent to do something, but then you do it anyway. And then the principal's like, cool, thanks for doing that. They ratified it later. So anyway, that's what that slide's all about. And you may see Harriet, sweet Harriet, on an exam. Okay. So let's see if I can get this to work. All right, so that's it for this lesson on agency. Again, think of it as a springboard into what we're going to talk about next class, which is employment law and how to, it deals with a lot of liability issues between employers and employees, and then we'll spend a great amount of time talking about the laws surrounding employer and employee relationships. We'll get into discrimination. We'll get into harassment as well. And so, yeah, that's it for today. We'll see you soon.